Yields back. Gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chair. I was quite interested in the dates that are set forth in your report, Mr. Herr. And the reason I'm interested is because I keep getting confused between the 2017 date and the 2024 date as to the condition of the president's memory. And so was there a difference? Because when I look at it, it seems like his memory was bad in 2017, and then it was bad today. But there's never any distinction made. But isn't it true that if you were going to be looking at at prosecuting as you were, you would look carefully at his condition in 2017? Isn't that the proper time? Because I think you say in your report that your best case, I think you call it out, the best case for charges would rely on Mr. Biden's possession of Afghanistan documents in his Virginia home in February 2017 when he was a private citizen and when he told his ghostwriter he just found classified material. That's the best case as you say it.
Yes.
And then you work your way through a series of defenses against your best case. So you were looking at his condition in 2017. Do I have that right?
You do, Congressman.
And his memory was bad then. We can draw our conclusions whether it improved over the next 6 years or not. But I just want to make sure it's clear that we're looking at his condition in 2017, which you then find as you go through the list of defenses that is his memory is bad, his memory is bad, his memory is bad. There's about 6 or 7 defenses here. And so what it gets me to is this question. And I actually pulled this quote out of something I read this morning, that perhaps your report concluded, and perhaps it did not, that the president is, quote, incapable of being held accountable. But that's not quite what happened, is it? You didn't find that he was incapable of being held accountable, did you?
I did not. Those words do not appear in my report.
They do not. But you reached a conclusion that you didn't have the evidence, but then your report continually recites these defenses. And I'm having a hard time putting the two together. If you didn't have the evidence, why do you persist in reciting these defenses?
Congressman, I wrote my report as an explanation of my decision to decline charges as to President Biden. And the way that I came up with that explanation and wrote it in my report for the Attorney General is the following. The approach that I took was a prosecutor envisioning what would be the probable outcome of trial if we charged this case, if we presented the evidence to a jury, and not only the government presenting the evidence to a jury, but what would happen if the defense lawyers also got a chance to try to poke holes in the government's case at trial. And with respect to one of the several potential defenses that I lay out in the report, one of them does focus on the president's memory-related issues. That is a defense that the president's defense lawyers may well present at trial. And a jury is going to be confronted with at least 3 separate sets of evidence relating to the president's memory. One is from the recordings in 2016 and 2017 from the ghostwriter.
But if I may, forgive me for interrupting, but I'm limited on time as everybody else was. But you say, I think, that the evidence suggests he is incapable of forming, or you're incapable of proving, intent. And there's kind of a bit of a difference there, right? You may well have had the intent, but you could not of holding these documents, and I hate to say hiding the documents, but you couldn't prove it. So what you did instead is fell back to the various defenses that might also be asserted against you. Kind of a heap of rationale for not pursuing the president. Is that, do I have it right now?
Congressman, I think we're on the same page. I think what I'm trying to convey is that the way that prosecutors assess the strengths and weaknesses of their case is to think through, hey, in the government's case in chief, here's the evidence we're gonna present, and the jury might be with us. But that's not the end of the trial. The trial also has to include presentation from the defense lawyers.
You're correct, and I'm a lawyer. I've tried cases, so I get it. Your report is not an exoneration so much as a determination that the evidence as you saw it would not overcome the defenses that you had identified, plus whatever lack of evidence you perceived. So it's not an exoneration, is it?
The word exoneration does not appear anywhere in my report, and that is not my conclusion.
The other thing that's of interest, and I think you were misquoted, you said something about, or someone, I think it was Mr. Raskin, suggested that you I'm going to run out of time, but I appreciate the work you do as a prosecutor, and I yield back.
Gentleman yields back. Mr. Herb, we've been at this close to 3 hours. We will, if you can hang with us, we'd like to keep going. There's a chance we could complete votes by the time we have to go to votes on the House floor, which would be about 1:40.
I can keep going, Chairman.
Okay, then we'll try to do that. There's a chance we may not too, but I just wanted you to know the lay of the land. Now I yield to the gentleman from Colorado.
Thank you, Mr. Chairman. Thank you, Mr. Herr, for your testimony and for your service as a prosecutor at the Department of Justice. I want to focus a bit more on the progress of the investigation and kind of some process questions. So you were appointed by Attorney General Garland as special counsel to investigate the president's handling of classified documents in January of 2023, correct?
Correct.
And Attorney General Garland, of course, as you know, was nominated by President Biden to serve in his role.
Correct.
During your 15-month investigation, did the Attorney General attempt to interfere with your investigation?
No.
Did he impede your investigation in any way?
No.
Did any other member of the Department of Justice or within the administration refuse to cooperate with your investigation?
No.
Were you ever denied access to materials, witnesses, resources from Attorney General Garland that you might have needed during the investigation?
No.
You submitted, I think this is right, your final report to Attorney General Garland on February 5th of 2024.
Correct.
Right, okay. And it was then released publicly 3 days later, on February 8th of 2024. Is that right?
I believe that's true, yes.
In the final report that was released, were any of your substantive findings redacted or changed in any way?
No.
None of your findings were modified by the Attorney General?
No.
Did the Attorney General issue any kind of statement or a letter attempting to describe the contents of your report?
No.
Okay. You're familiar, I know, I'm sure, with the investigation that was conducted by Special Counsel Mueller years ago with respect to the former president.
Yes.
And at that time, Attorney General Barr was in charge of the Justice Department. He sat where you sat in this committee. I remember it well, just a few short years ago, testifying on the nature of that particular investigation. Are you familiar with the way in which he released that report and characterized it?
Yes.
Okay. Very different from the way that Attorney General Garland conducted this particular release. I take it you'd agree with that.
They were not the same approach.
Not the same approach, right? In the case of Attorney General Garland, no impeding or interfering with your investigation in any way whatsoever, releasing the report in full to the American public, not attempting to mischaracterize it or describe it in any way. Dissimilar from Attorney General Barr, who 5 years ago, as you recall, after Special Counsel Mueller submitted his report to the Department of Justice, took nearly a month to release the report to the American public, heavily redacted, and not before he had issued a letter of his own to the leaders of the Senate and House Judiciary Committees, mischaracterizing the contents of that report. That distinction and difference is very important because from your testimony, at least from what I gleaned from your testimony, is that Attorney General Garland acted appropriately and ethically with respect to this investigation. I take it you agree.
Attorney General Garland did not interfere with my efforts, and I was able to conduct a fair, thorough, and independent investigation.
Very different approach, as you said, from the way in which the Department of Justice, unfortunately, tragically, functioned under the former president. I'm going to yield back the balance of my time.
Gentleman yields back. The gentleman from Alabama is recognized for 5 minutes. Would the gentleman yield for 10 seconds? Gentleman from...
Yes, sir.
Yeah, I would just point out to the gentleman from Colorado's last point, there was one big difference. Bill Barr didn't name Bob Mueller as a special counsel. Bob Mueller was named by Rod Rosenstein. That's a huge difference in how this whole thing works. I now yield back to the gentleman from Alabama.
Thank you, Mr. Chairman. Mr. Herr, in your report, you cited principles of federal prosecution and observed that, and I quote, historically, after leaving office, many former presidents and vice presidents have knowingly taken home sensitive materials related to national security for their administrations without being charged with crimes. And this historical record is important context for judging whether or why to charge a former vice president or former president, unquote. Why is examining this history so important?
Congressman, one of the reasons that it was important was because it would bear on how a jury would perceive how how a jury would decide whether or not criminal willful intent was formed by the person retaining or disclosing the national defense information at issue.
Has there been an exception to this in the history of the nation? Have we charged any former presidents?
As I state in the report, to my knowledge, there is only one exception, and that is former President Trump.
Given the history, is it fair to say it's preferable not to charge a former president or a vice president for allegedly mishandling classified documents, in your opinion?
Congressman, I can't articulate a preference, whether it's preferable. All I can talk about is the work that I did, the facts that I found, and the decision that I reached in my case.
Mr. Hur, what's the difference in a U.S. Senator having documents and a former president of the United States?
For purposes of proving willfulness, I believe that there would be a number of differences in terms of the types of access and the ease with which presidents, while in office, can access classified information as compared to the access privileges that senators have.
Can presidents declassify documents that they have in their possession?
I believe under certain circumstances, yes.
Former presidents as well?
Congressman, I confess this is not an area of the law that I've looked into or explained in my report, and I'm here to talk about the work that is reflected in the report.
Well, let me say this, sir. You have a reputation beyond reproach, and I just want you to know that. I think that President Biden ought to be thankful that the Attorney General appointed you to investigate his case. But you have a special counsel colleague by the name of Jack Smith who cannot lay claim to such a reputation. Isn't that right?
I have no opinion. I don't have anything to say about it.
In fact, Jack Smith, whom Biden Justice Attorney General Garland appointed to investigate President Trump, has a reputation, according to deep-rooted reporting from the Washington Times, as an overzealous prosecutor who relies on ethically dubious tactics, unquote. And his prosecutorial record is replete with a quote, let me say this, string of mistrials and overturned convictions. Actually, Chief Justice Roberts once rebuked Mr. Smith's prosecutorial theory as a boundless interpretation of federal bribery statute. That did not comport with the text of the statute or the precedent of this court, according to the Supreme Court Justice. And so, my question is, do you think in the case of Jack Smith, do you think justice is blind when he's looking at President Trump? Since we've never done this in the history of the country, is justice truly blind?
Sir, I'm not here to express any opinions with respect to a pending case against another defendant. I'm here to talk about the work that I did with respect to the investigation relating to President Biden.
Mr. Chairman, I'll yield the balance of my time back to you.
To this conclusion.
Congressman Jordan, I'm sorry, but the mic was turned on partway through your...
Can you explain what specifically in your interview with President Biden led you to this conclusion?
The conclusion
that
about
broad statement that's been cited many times.
The totality of the time that I spent with the president during his voluntary interview was something that I certainly considered in framing my assessment and articulating it in the report. And that includes not only the words in the cold record of the transcript of the interview, but also the experience of being there in the room with him and, frankly, considering how he would present to a jury in a criminal trial if charges were brought.
But I guess I'm asking specifically. I know you cite in the report the dates that he couldn't remember when he was vice president, when he began, when his term ended. You cite that in the report. Is there anything else specifically that stands out from that interview with the president?
A number of things stand out. And again, I'm aware that the transcript has now been made available. I do provide certain examples in my report of significant, personally painful experiences about which the president was unable to recall certain information. I also took into account the president's overall demeanor in interacting with me during the 5+ hour voluntary interview. So it was a wealth of details about being there in the moment with the president, including his inability to recall certain things. And I'll also say, as reflected in the transcript, the fact that he was prompted on numerous occasions by the members of the White House counsel's office.
I read that. The brief look I had at the transcript this morning, because we just got it this morning, I saw some of that. Chair, now recognize the gentlelady from Texas, or excuse me, Pennsylvania. I'm used to you being down there. The gentlelady from Pennsylvania.
I got an upgrade.
Okay.
Thank you, Mr. Hur. Thank you, Chairman. Thank you, Mr. Hur, for your service to our country, for your team's service in this investigation. You determined, after what you described as rigorous, detailed, and thorough analysis, that President Biden should not be prosecuted for mishandling classified documents. In fact, everybody can take a look at your report. The very first sentence says as much. It says, quote, "We conclude that no criminal charges are warranted in this matter." Am I correct?
Yes,
That's the bottom line of this report. Am I correct?
that is the first sentence.
It's the first sentence and the bottom line. There's an awful lot of misinformation that has been put forward by the press in some cases and also by the other side of this dais. You didn't reach this decision because President Biden was sympathetic. Is that correct?
I reached the decision based on the totality of the reasons that I set forth at length in my report.
Based on the evidence. And while Mr. Trump, who is being prosecuted, is not sympathetic, you didn't calibrate any of that in there. Sympathetic, not sympathetic. Doesn't matter. It's the evidence, right?
Congresswoman, I did not reach any assessments of the evidence in the Trump matter. To the extent that I considered the allegations against former President Trump, it was for purposes of comparing relevant
trust
precedents.
That with your credibility, you were not out to get Mr. Trump, nor here to help Mr. Biden. I think it's about the evidence, and I think you say that over and over again in your report. Why did you decide President Biden should not be prosecuted? Your report tells us, quote, "We conclude the evidence is not sufficient to convict." Those are your words. Is that correct?
I believe if those exact words do not appear in the report, that is consistent with the gist of my conclusion.
Very good. They are your exact words. That was not the case with Donald Trump. You have a copy of your report today, don't you, in front of you?
I do.
Could you read a portion of it for me? Your words, it is page 11, starting on line 3, beginning with the words, "Unlike the evidence involving Mr. Biden." Would you read the next few sentences?
Unlike the evidence involving Mr. Biden, the allegations set forth in the indictment of Mr. Trump, if proven, would present serious aggravating facts.
Keep going.
Congresswoman, I'm happy to have you read the words in my report.
Well, it's your report, so I think it actually is more fitting that you read those.
Most notably, after being given multiple chances to return classified documents and avoid prosecution, Mr. Trump allegedly did the opposite.
Keep going.
According to the indictment, he not only refused to return the documents for many months, but he also obstructed justice by enlisting others to destroy evidence and then to lie about it.
You may stop there. Thank you. You mentioned the indictment against Mr. Trump for mishandling sensitive classified national security information. That indictment says at the end of his presidency, Mr. Trump, I'm looking for my indictment here. I have it here. Hang on. Mr. Trump himself ordered that boxes containing classified materials go to Mar-a-Lago, where he hosted tens of thousands of guests. Then he kept these sensitive materials carelessly about the property, as you can see here. Classified documents ended up in a bathroom, a ballroom, on a floor, spewing about. And when a grand jury subpoenaed the documents, what did Donald Trump do? The indictment again shows against him what he responded by, suggesting that his attorney falsely represent that the FBI and grand jury that he did not have documents called for by the subpoena. He directed his employee, Waltine Nauta, to move boxes of the documents to conceal them from Mr. Trump's attorney, and then lied to his attorney and the FBI and the grand jury, suggesting his attorney might hide or destroy documents called for by the grand jury investigation. Mr. Hur, are those the type of aggravating facts to which you refer to in your report?
Congresswoman, the aggravating facts that I refer to in the report are set forth and described in my report at page 11.
Very good. Mr. Hur, to the best of your knowledge and investigation, did President Biden ever direct an employee to lie about, hide, or destroy classified information? Yes or no?
We did not identify such evidence.
Did he do so himself?
We did not identify such evidence.
And I want to give you a chance, since the transcript is out, to correct the record on an important point. Very sadly, your report on page 208 says that Mr. Biden couldn't come up with the date, the year of his son, Beau Biden's death, when in fact in the transcript it shows that you asked him the month. And do you know what he said, Mr. Hur? He said, "Oh God, May 30th," Would you like to correct the record? His memory was pretty firm on the month and the day.
Congresswoman, I don't believe that's correct with respect to the transcript, but if you could refer me to a specific page, I'd be happy to look.
I've read about it in reporting. Thank you. I yield back.
Chair now recognizes Mr. Kiley.
Mr. Hur, why did the White House ask you to remove parts of the report? What was the reason they gave for that?
I don't have the letter in front of me, Congressman. I believed that among their reasons was that they contested or that they asserted that certain language in the report was inconsistent with DOJ policy.
The day that your report came out, the president gave a live news conference on national television. Did you watch that news conference?
I watched the press conference, yes.
What was your reaction to seeing the president personally attack you and your team?
Congressman, I'm here to talk about the work that went into the report and my declination decision and my explanation of it for the attorney.
And it wasn't just the president. Anthony Coley, former spokesman for Merrick Garland, has said that Democrats should focus their ire on her. The president's personal attorney, Bob Bauer, said that your report is a shabby piece of work and a shoddy work product. Do you agree with that characterization of your report?
I disagree vehemently with that characterization of my report.
I also disagree. I think it's very well written, well considered, and comprehensive. Do you think it's appropriate for the administration to be attacking the work of a special counsel that it appointed itself?
Congressman, I'm not going to comment on the propriety of the administration's reaction to my report. What I can tell you is that I stand by the report and the work that went into it.
Today, the ranking member started his opening statement by saying, Mr. Hur completely exonerated President Biden and called your report a total and complete exoneration. Mr. Hur, did you completely exonerate President Biden?
That is not what my report does.
Was your report a total and complete exoneration?
That is not what the report says.
So the statement by the ranking member was incorrect, yes?
As I said, the report is not an exoneration. That word does not appear in my report.
Based on the facts and anticipation of defenses presented in your report, could a reasonable juror have voted to convict?
As I said in the report, some reasonable jurors may have reached the inferences that the government would present in its case in chief at trial.
So a reasonable juror could have voted to convict based on the facts that you presented?
Correct.
If you were on the jury, would you have voted to convict?
I have not engaged in that thought exercise, Congressman, and so what I'd like to stick to is what's in the report, which is my assessment as a prosecutor.
Sure. And what you did find in the report is that the president, you said this is page 200, risks serious damage to America's national security through his handling and mishandling of classified materials. And you identify, quote, a strong motive for the way he handled those materials. Two of the motives you cited was his desire to run for president and his desire to sell books. So a reasonable inference for your report is that the president risked serious damage to America's national security in order to make money and advance his personal political ambitions. Is that correct?
The report includes a description of the evidence and different inferences that reasonable jurors could draw from the evidence.
And you also note that the president described his predecessor's handling of classified materials as totally irresponsible. And your report concludes that Mr. Biden's emphatic and unqualified conclusion that keeping marked classified documents unsecured in one's home is totally irresponsible applies equally to his own decision. Is that correct?
That language does appear in the report.
You cite as a mitigating factor the fact that the president cooperated in the investigation. But at the time that the investigation was happening and these acts of cooperation occurred, the Mar-a-Lago investigation was already a matter of public record, correct?
I believe that's correct.
So we already had a public debate about the handling of classified documents and the potential application of the criminal laws to that general set of circumstances.
I think that's fair.
And so the president, when he decided to cooperate or not cooperate, had to know that that decision to cooperate or not cooperate would become known to the public and he would be judged accordingly. Is that correct?
I'm not in a position to opine on what was or was not in the president's.
But it's relevant to your analysis as to whether or not it counts as a mitigating factor. If he knew that he was going to have to be judged based on whether he cooperated or not, that would lessen its value as a mitigating factor. So did that in your analysis lessen its value?
We undertook a comprehensive assessment.
So that specific factor, did it lessen its value as a mitigating factor?
That and all facts relating to the president's cooperation with our investigation.
Another factor you discuss is deterrence. And you say that deterrence the factor actually counsels against bringing charges here because you said, as for general deterrence, future presidents and vice presidents are already likely to be deterred by the multiple recent criminal investigations and one prosecution of current and former president and vice presidents for mishandling classified documents. So that one prosecution, of of course, is the indictment brought by Jack Smith. So by the very terms of your analysis, Jack Smith's indictment actually counseled against and was counted against bringing charges in this case. Is that correct?
I'm sorry, Congressman, I don't follow your drift there.
Well, you said that there's already deterrence because there's this prosecution out there in a prior case related to classified documents. So we don't need to bring another case to establish deterrent value. That was the essence of your analysis, correct?
Congressman, what I'll say is that I will stand by the way and the specific words in which I characterize my assessment of deterrence value of a case under the principles of federal prosecution that's on page 254 and 255 of my report.
Thank you. My time is out, but I'll just add the perverse implication here is that the administration, by the very terms of your analysis, actually made it less likely that the president would face charges by Jack Smith bringing an indictment. Thank you.